Good morning to everyone. We're on the record. This is Cannabis Compliance Board, November 15th, 2020. First order of business, as always, is call the roll to make sure we have a proper quorum.
Member Merritt,
Present.
Member Durrett,
Present.
Member Nylander,
Here.
Dr. Young, here, and Chair Douglas.
Here. With that, I will note for those present today on item 7, which is the various testing issues that are brought forth in item number 7 as to regulations 1, 6, and 11 for possible consideration and action. I would ask that we hold public comment until that matter comes up so that we can hear the public comment in context of that item, opposed to having it done before we take these other items. With that, it's appropriate to have our first public comment of the day as to any other issues.
Good morning, everybody. For the record, my name is Bree Padilla, and I am the Secretary of the Chamber of Cannabis, as well as an industry advocate and professional. I work specifically in the event space, empowering women to create opportunities for themselves in ancillary and licensure capacities. I'm speaking today in relation to the proposed changes to Nevada regulations as they relate to public cannabis events discussed during the 1110 CAC subcommittee meeting on public health. While I think we can all agree the time for cannabis events to be regulated in public is coming, the approach in the proposed changes is one that leaves many questions and concerns unanswered, while also allowing for some of the systemic issues identified in the industry to continue unabated. From the minimum size of the
Sorry, this is the court reporter, and you need to read way slower.
Sorry.
Yeah, so,
All right.
it was way too fast. Thank you.
Okay, I got you. Do you want me to start over for you?
Honestly, that would be great. Thank you.
My pleasure. Oh, you guys got to hear me talk longer. For the record, my name is Bree Padilla, and I am the Secretary of the Chamber of Cannabis, as well as an industry advocate and professional. I work in the ancillary space, creating cannabis events for women leaders and providing opportunities for them. I'm speaking today in relation to the proposed changes to Nevada regulations as they relate to public cannabis events discussed during the 1110 CAC subcommittee meeting on public health. While I agree the time for cannabis events to be regulated in public is coming, the approach in the proposed changes is one that leaves many questions and concerns unanswered, while also allowing for some of the systemic issues identified in the industry to continue unabated. From the minimum size of the petitioned public events, 25,000 people, to requirements like 200,000 in liquid assets, it is clear this is positioned so that the regulations will benefit multi-state conglomerates by empowering them to engage in economic activity that other smaller local licensees and equity owners would not have access to based on means. When there is such a concern about equity and access to ownership in cannabis, it is disheartening to see proposed language that reinforces standards that our own regulatory bodies have acknowledged are deleterious to the diversity of our industry. Nevada has never been the first to rush to market with any model as it relates to cannabis, and this has been to our benefit. I urge the CCB and CAC to take into consideration the suggestions provided by the Subcommittee on Diversity, Inclusion, and Equity as they relate to these proposed changes, as well as options that allow for opportunities in competition and engagement by those businesses that are not MSOs or out-of-state entertainment conglomerates. In particular, I urge the CCB to establish clear guidelines that offer smaller and new licensees the opportunity to engage in this emergent space while also holding existing licensees to a higher standard, particularly those who have let their social responsibility plans fall by the wayside. I can also give this to you wherever you are.
Thank you.
Good morning. For the record, my name is Danny Baranowski. I'm a longtime industry advocate and vice president of the Chamber of Cannabis. In the next few days, over 35,000 members of the global cannabis industry will descend upon Nevada. I look forward to bragging to colleagues from other markets about the innovative opportunities and policies we have in place here, such as our reformed cannabis DUI laws and the upcoming consumption lounges. As a committed member of the cannabis industry, MJ BizCon is an incredible opportunity to show the world what is possible here in Nevada. In September, a roundtable of industry leaders recommended specific regulations be amended to enable the industry's growth and development. Has the CCB considered implementing any of these solutions, many of which will increase revenue and promote viable business opportunities? Since that roundtable in September, many chamber members have experienced market compression and other business disruption. This compression has resulted in many companies laying off employees. Unfortunately, I was one of those. One major area of concern is the slowing pace of venture capital investment in our industry. In 2021, total investment was $1.6 billion, and this year has fallen to only $300 million. With capital becoming more scarce and expensive, the regulations and policies implemented by this board will directly impact where these investors and entrepreneurs choose to put their money. As the international cannabis community descends upon our market, all eyes will be on us. It is incumbent upon all of us to use this opportunity to create economic growth, to move the industry forward, and revisit the important suggestions made by committees, workshops, and roundtables. The Chamber has created a Commerce Committee, and beginning in 2023, leaders are prepared to provide insight and resources wherever we can. This collaborative approach to sensible regulation can be an example to the industry, so that as thousands of cannabis business people visiting this week contemplate expansion, they look to Nevada first as a thriving and conscientious market. Thank you for your work, and I look forward to continuing to collaborate and define the future of Nevada cannabis.
Thank you. Other public comment here in Las Vegas?
Good morning, board. My name is Tanya Haven for the record. I am a licensed cannabis seller here for the city of Las Vegas, excuse me. And I just wanted to say thank you very much for being here. I appreciate so very much that you open the meetings to the public so that we can come in and be a part of the evolution of the industry. And I can already feel the excitement in the room from everybody. So thank you. Let's pass it on. Have a good day.
Other public comment here in Las Vegas at this time? Seeing none, do we have any public comment in Carson City this morning? Okay, then. We have one.
One moment, sorry. Hello, my name is Will Adler, and I am the Director of Silver State Government Relations. Silver State Government Relations was hired by a group of laboratories here in Nevada some years ago called the Scientists for Consumer Safety. My time spent as the Director of Scientists for Consumer Safety was some of the proudest time I've spent in the cannabis industry, but I no longer represent that group and their efforts at this time. That group was disbanded and dissolved some years ago as well, but and we allowed the LLC to go into default. But I do want to say that I've been made aware that, yeah.
Mr. Adler, if you were speaking anything reference to the item number 7 as regulations, I asked earlier if you'd hold that until that item comes up so we have everything in context at that time. If this is
I
not
was
about
clarifying
that,
my firm's position prior to that meeting.
well, I
the
prefer
agenda
that you
item.
wait. I prefer that you would wait until that item pops up.
Okay.
And
Thank you, sir.
we have any other public comment not germane to that item? That being the case, we will proceed to item number 2, meeting minutes from the October 25th, 2022 Cannabis Compliance Board meeting for possible action. If members of the board have reviewed and have don't wish to make any corrections or other comments, if we can get a motion on that.
Member Drat, I move to approve the meeting. The minutes from our previous meeting.
A motion for approval. Do we have a second as to that motion?
Member Merritt, I second.
Motion for approval in the second. Any additional discussion or comments? If not, all in favor, please say aye.
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 Matter carries unanimously. That moves us to item number 3, consent agenda complaints.
Thank you, Chair. Item 3A on the agenda concerns 2 complaints for disciplinary action. Pursuant to NRS 678A 510, the Attorney General has reviewed these violations and has recommended proceeding with disciplinary action. I'm requesting the board's approval to proceed with each of these 2 disciplinary actions, and if approved, I will then authorize service of the complaints. As to Respondent A, the complaint will allege violations of NCCR Regulation 4, 6, 9, and 10. And as to Respondent B, the complaint will allege violations of NCCR Regulation 4, 6, and 10. With that, I'll turn it back to you, Chair.
Been presented in the abstract, the 2 complaints that are listed under item number 3 for approval to proceed with disciplinary action. And as we've said before, the board has not seen these matters to date. We are just approving the process of these matters going forward at this time pursuant to the direction of our executive director and staff. With that, do we have a motion from board members?
Member Dret, I move to approve proceeding with serving the complaints listed under agenda item 3A, as to respondents A and B.
Member Merritt, I second.
It's been moved in second. Do we have any additional discussion or questions reference complaints under item 3, 1, and 2? If not, all in favor of moving forward with that, please say aye.
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 Matters carry unanimously. That takes us to item number 4, consideration of the proposed settlement agreements to resolve disciplinary action. I have one item, Cannabis Compliance Board versus Helios Nevada LLC.
Good morning, Chair, members of the board. For the record, I am Senior Deputy Attorney General Ashley Balducci. I'm presenting for the board's consideration item 4A on today's agenda. Item 4A is the amended stipulation in order for settlement of disciplinary action in case number 2021-46. As you may recall, Larry Birch is the cannabis receiver over Helios NV LLC. And Exhibit 1 is the original stipulation in order for settlement of disciplinary action that this board unanimously approved during the board's July 28th, 2022 meeting. Shortly after the board's July 28th, 2022 meeting, Helios had to vacate their premises where it was operating due to landlord-tenant issues. This presented issues for generating revenue and raising more capital. The amended stipulation in order for settlement of disciplinary action before you will allow Mr. Birch, the cannabis receiver, to sell Helios's licenses within a certain time period to pay the previously agreed to civil penalty and any other outstanding amounts owed to the CCB first, any and all taxes and interest owed to the Department of Taxation, post-receivership fees and costs incurred by the cannabis receiver, his professionals, and his vendors third, and any other creditors fourth. The amendment does not become effective unless it is approved by the CCB, Tax Commission, and the Receivership Court, with the effective date being whichever approval occurs last. This is, of course, just a brief summary of the primary terms of the amendment, with the full terms being provided within the document itself. For these reasons, it is recommended that the board approve this amendment. I'm available to answer any questions, and counsel for Helios and a representative from the Cannabis Receiver's Office are also present for any questions you may have regarding this amendment.
With that, can we have our representations from the parties for Helios?
Thank you, and good morning, everyone. Charles Giannelloni appearing on behalf of Helios. And then I have next to me Richard Kleikamp, who is from the receiver's office. Mr. Birch, the receiver, is attending a mandatory receivership training that he just simply could not reschedule this morning. However, Richard has been involved in this receivership since day one and can certainly answer any questions that the board may have for him. I just have a few comments. A little history might be helpful here, just to sort of wrap everything up. The board approved and commenced disciplinary action against Helios last year about this time, actually. At that same time, there was litigation going on between Helios's members who had filed in Washoe County against the manager of Helios. During the course of that litigation, Mr. Birch was appointed the receiver over Helios. One of his first actions when he took over in approximately January, February of this year was to remove the prior management team. Once that management team had been removed, it sort of paved the way for the stipulation for settlement that we took before this board for approval this summer. And just quickly, the contours of the unamended settlement, if you will, was a fine that was imposed on Helios of approximately $120,000. The requirement for a comprehensive plan of correction, strict tax compliance, and with all of those things, assuming the board approved, Helios would be allowed to continue to operate. That was the big tension in the settlement talks, was whether or not Helios should be allowed to operate or if it should simply just be forced to sell its licenses, and that was the end of the game. So with the board's approval this summer, the receiver set about doing two things that were necessary for Helios to continue to operate. The first thing the receiver did is he brought in all of the equity members and talked about the need for a capital call so that funds could come in that were necessary to allow Helios to operate while the production facility, the grow, if you will, ramped production back up to where it needed to be, which of course would give them the funds that they needed in the long term. So they needed a short-term sort of gap funding capital call. The second thing that the receiver needed to do was needed to enter into an agreement with the landlord for a new long-term lease. There was, when the receiver took over, the lease was month to month, which is of course not a great situation for any tenant. Unfortunately, the landlord was not willing to negotiate a long-term lease. Instead, sent a notice to vacate, which required Helios to be out of its grow facility within 30 days. That sort of had this cascading effect, which has ultimately brought us here. The members of Helios were no longer willing to respond to that capital call in any meaningful way. They just simply weren't willing to provide funding for a company that had no place to grow. So the receiver then made a difficult decision to shut the grow down, and that's exactly what happened. We called the CCB's officers in to oversee, unfortunately, the destruction of hundreds of pounds of cannabis on August 30th of this year, and then we're completely out of the property after a final inspection on the 31st. So as of today, Helios is no longer operating. So the reason that we're here is to figure out if there was anything left that Helios could do to sort of salvage anything. And what we're asking for is approval, now that Helios is in wind down mode, for the ability to sell these licenses in approximately 90 days. I believe the agreement contemplates we have until March 1st. As to the sale proceeds, which I think is the important part, that's what we spent the most time on when we were negotiating. Of course, the CCB gets paid first. The remaining amount that's due under the agreement, it's $120,000 less the payments that were made up until Helios shut down. And then second, with the help of the Department of Taxation attorneys, they are sort of second in the waterfall. So the CCB gets paid first, and then the Department of Taxation gets paid second. And of course, the settlement is conditional on court approval in the Washoe action, as well as the Nevada Tax Commission, which I assume will be our next stop. The court in the Washoe action has a motion to approve this agreement right now. It's negative notice up there, so there's no hearing date. It's the way I understand it. But we are not aware of an opposition yet. So what we expect will happen next is that the attorneys that are handling that will submit an order to the court for approval, which will give us that piece. Of course, if there is an opposition, then it's not certain, but so far so good up there. And then the Nevada Tax Commission's approval, and then finally this board's approval. So that is kind of how we got here, why we did what we did with the original settlement, and then the unfortunate need, I think, to enter into a settlement that just simply allows us to sell these licenses and then pay the appropriate state agencies. With that, I've got nothing else.
Any additional representation you should make?
None at this time.
Questioning by board members at this time as to this amended proposal.
Yeah, Mr. Chairman, this is Member Nylander. I appreciate that very thorough explanation of the background. And, you know, we've heard this before, and unfortunately it's a business dispute, you know, that led to this juncture. And I don't have any questions. I'm satisfied with the explanation. And, you know, this seems like a good way to kind of resolve this, and so that the receiver can finish what they're doing and go down the road and you know, get these licenses sold and to try to revamp everything. So it's unfortunate, but you know, it's a business dispute that happens all the time. It's not just the cannabis industry. You know, it's just one of those things. So, but I do appreciate for counsel your thorough explanation of the background. It was helpful because we've heard this before. It's been a long time. It's nice to hear a current recap of what's going on. So thanks, Mr. Chairman.
Other board members? If not, from the chair, the only comment I have is that hopefully upon our approval of this, if there is any other deviations from any of the other parties that have to approve or the court, you will relate back to us to let us know what the status is, that A, it's been approved, or B, had to rework something.
Certainly.
Yeah, but with that, do we have a motion as of this amended stipulation in order for settlement of disciplinary action?
Mr. Chairman, this is Member Nylander. I would move for approval of item 4A.
We have a motion for approval of
Member Young, I'll second that.
and a second as to item 4A. With that, if there's any additional comments that wish to be made, please make them. If not, all in favor, please say aye.
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 Matter carries unanimously. Thank you very much, and good luck. And hopefully you can bring this to an end for everybody.
Thank you.
Thank you, everyone.
That takes us to item number 5, request for transfers of interest. TGIG LLC, first matter up under that one.
Good morning, Chair Douglas, Member Merritt, Member Nylander, Member Durrett, and Member Young. For the record, I am David Staley, Division Chief of Investigations for the CCB. I'm here to present agenda item number 5, which consists of 3 transfer of interest or TOI applications. Item number 5A is the TOI application by TGIG LLC. TOI number 21056 was filed for approval of internal transfers within the existing ownership structure due to a capital call and recognition of trustee changes upon the death of a co-trustee. No areas of concern were identified during the investigation into this TOI application. I am available for any questions, and my understanding is that Demetrius Curatus, John Ritter, Merle Toomey, and John Bertocini are available to address any questions you may have as well. With that, Chair Douglas, I will turn this item back to you.
Do we have any of the proponents, the licensees available in person or on video this morning?
Amber, I'm seeing you shaking your head. Just, Mr. Chair, I'm not familiar. They were all noticed and they responded with their waiver, their signed waivers. We anticipated that they would either be here or by Zoom.
Well, to move to the agenda, I'll ask the first question, whether or not the board has any questions or concerns they wish to ask. If they do, then we'll hold the item. If not, we could, I assume, we can just go forward and approve it. I'm not happy to not being present, but pleasure of the board.
Mr. Chairman, just a question for Mr. Staley. So it looks like this is another one where there was a capital call and some of the members either didn't want to or couldn't participate. And so that's resulting in a transfer of interest among the existing members. Just want to make sure I understand it since their representatives aren't here.
Yes, Member Nylander, the capital call and the members of one of the Palo Verde Associate Assets LLC, there were, I don't believe that the capital contributions matched the original interest they held in this entity, and the differences in the capital call created changes of the ownership makeup of the entity, and that was resulted in the TOI.
Okay, so it's just dilutive to the members who did not contribute or didn't contribute the full amount of the capital call.
Yes, sir, that's my understanding.
Okay. I did not have any other questions, Mr. Chairman.
Thank you. Other board members wish to weigh in or at this?
Member Drat, I know this licensee from working with them for years, and it's very not like them to not be present somewhere. So I'm sure there's some issue that I'll be able to explain later. And so I would feel comfortable going forward.
I will note for the record that we make a request that they be here so that if there are questions, the board has a chance to work them out. Otherwise, we would just kick this matter to the next agenda for consideration. That's in 30 days. The business is kind of still in limbo. Just to remind people, when you're asked to appear, we do ask you to have someone here. In the future, we will not just waive the appearance. This has been prearranged. We will just kick it 30 days. But with that, do we have a motion for approval since there's no major questions as of this item?
Member Drat, I move to approve.
Thank you. Do we have a second?
Member Merritt, I second.
Moved and second. Any other discussion? With that, all in favor, please say aye.
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 Any nays? Okay. No nays. Matter carries unanimously. Takes us to item B, Just Quality LLC.
Chair Douglas, members of the board, for the record, my name is David Staley, Chief of Investigations for the CCB. Item number 5B are TOI applications by Just Quality LLC and the Cure Company NV LLC. TOIs number 19030, 21063, and 2200025 were filed for internal restructuring of Just Quality, resulting in Ron and Norma Memo acquiring Paul Thomas's membership and the sale of Just Quality's medical and adult use cultivation licenses to the Cure Company NV LLC. No areas of concern were identified during the investigation into this TOI application. I am available for any questions, and my understanding is that Adam Fulton, Ronald Memo, Paul Thomas, Patrick Stad, Michael Melendez, Brandon Melendez, and Arthur Hodge are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Representations this morning.
Thank you, Chairman. Good morning, board members. Adam Fulton for the record. On behalf of Just Quality, Conjurium, and the Cure Company Nevada LLC, and everybody that Chief Staley just mentioned is also here.
Anything that you would like to say? It looks like you've done your work and everything is too easy this morning.
So far, Your Honor. We'd like to just thank staff actually on this one. This one was a little complicated and we appreciate their work with us. Rachel and Chief Staley and Danny working through us with us on this one was a little complex from a legal standpoint, but we were able to work with them and get it done. We appreciate their hard work and diligence in making sure we get this one across the finish line and done. So we thank them.
Yeah, this was interesting in terms of series LLCs that are involved in the separations for liability purposes. With that, any questions or anything board member wishes to ask?
Mr. Chairman, this is Member Nylander. And this is for both Mr. Staley and Mr. Fulton. This series, I'm sort of very interested in this because Series LLC, I've not really seen this much. And I live in a gaming cave, so I don't. So is this common now, or is this something that's new?
Member Nylander, it was new for us as well, and it did require Agent Sandrock to do quite a bit of kind of review on this kind of structure before we were really kind of comfortable with it. In practice, it appears that the series underneath what you would call the parent LLC have separate distinct members, and they also have separate distinct assets. And one of those assets included in this structure is the license. After review with the DAGs, we were comfortable handling the two series as conceptually subsidiaries of the Just Quality LLC, which we consider the parent. So going forward, we have it's not really an issue with the cultivation series because those are going to the cure, but production will stay under Just Quality LLC. We have determined that the appropriate way to handle it is to recognize the production series Just Quality LLC as the ultimate licensee, with Just Quality LLC recognized as the parent. Our conclusion was that since both had members and both had kind of were considered a legal entity in their own right, even though one was a series of the parent, our licensing will reflect that the production series will be the licensee.
Adam Fulton again for the record. So the series entity or the series structure is not incredibly common. I would say it's uncommon for sure, Member Nylander. But it does provide certain advantages from a structural standpoint and operational standpoint, and also a tax standpoint. So there are different advantages to using the series over a holding company or a parent company to an underlying entity, which is what I'm sure you're familiar with. Coming from the gaming industry, they usually have holding companies, then subsidiaries under them. The series is very similar to that, but provides some distinct advantages and also structure context.
Yeah, no, I appreciate that. And I think it's, the language that's used is it's a master LLC and then these series. So it's just sort of, it was just kind of foreign to me. So I appreciate the explanation. And I also, for Mr. Staley, appreciate the way your staff put the report together, because it is a complicated matter and different for me. I mean, I'm used to seeing bankruptcy proof things but this has more tax implications, other things that are, it's just, I haven't seen this in my time on the board here. And again, I appreciate the staff's efforts in putting together the report, because this was, different and sort of complicated. But I don't have any more questions, Mr. Chairman. I'll shut up.
No, I think you said a lot that other board members are feeling with that. Any other board member wish to weigh in on this item? If not, I will just echo the comments of Dennis. As to this, we're still grappling with LLCs sometimes in terms of disclosure for purposes of what the legislature set out. We appreciate our team and their going in depth into this. We also appreciate, Mr. Fulton, your work laying this out, since this is the first time we've seen this, because this industry is getting more complex and unfortunately, so to speak, and I hate to say this, more legal every day. With that, unless a board member has a comment, can we have a motion on this item?
Mr. Chairman, this is Member Nylander. I would move for approval of item 5B, the Just Quality LLC TOI as stated on the agenda.
Thank you. We have a motion for approval of item B under item 5, Just Quality. Do we have a second?
Member Durrett, I second.
Motion, we have a second. Any additional discussion? If not, all in favor of approval of this TOI, please say aye.
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 Matter carries unanimously. Thank you. Thank you, gentlemen.
Thank you very much.
Thank you, guys.
That takes us to item number C, a New Leaf Cultivation Center LLC.
Thank you, Chair. For the record, my name is David Staley, Chief of Investigations. And to echo your comments of the report, I have to thank my staff as well. They make my job much easier up here. Item number 5C are TOI applications by a New Leaf Cultivation Center LLC, a New Leaf Production Center LLC, and Alexander Hose. The New Leaf entities are currently owned by Michael Morgan, Catherine Lundgren, and Alexander Hose. The three members placed the New Leaf entities into a voluntary receivership due to difficulties agreeing on how to manage its operations. TOIs number 22-00035 through 22-00038 were filed requesting approval for Hose to ultimately acquire 100% of both New Leaf entities, then place his ownership into his wholly owned company, 800 Stillwell LLC. In essence, the proposed transactions require a two-part action by the board. The receivership court has approved the settlement by the parties, so the board may approve the transfer of New Leaf entity membership from Morgan and Lundgren to Hose. However, the receivership court has not yet approved the transfer of Hose's membership in the New Leaf entities to his company, 800 Stillwell. If the board does approve the transfer of Hose's membership to 800 Stillwell, staff suggests that the board's approval be conditioned to only become effective after the receivership court approves the transfer as well. I am available for any questions, and my understanding is that Jeff Donato, Dotan Melek, Edward Humphrey, Alexander Hose, Michael Morgan, Leslie Bryant, Anthony Arger, and David Edelblut are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Introductions as to New Leaf and your comments, sir.
Yeah, good morning, everyone. My name is David Edelblut. I am counsel for the receiver, Dotan Melek.
Good morning, members of the board. Jeff Donato here for Argentum. I was engaged for the purpose of putting together the application and submitting it with the CCB, but I don't represent any of the parties here today.
Good morning, board. Ed Humphrey on behalf of Alex Hose and 800 Stillwell.
Good morning. Any representations you'd like to make this morning?
Yes, Chief Staley did outlay it very well. This is a two-stage process. Everything that led up to this was a settlement with the Morgans that would result in Mr. Hose acquiring their membership interest, which is currently held under a company called Morganics LLC.
Excuse me, this is the court reporter, and I cannot hear the person. I think they're in Carson City. They're cutting out. I can hear everybody in Las Vegas fine, but the person that's on the mic, and I had trouble hearing the other person earlier on that mic. So I'm not sure if it's the microphone or what, but they're cutting out.
Is that any better?
It's better if you're closer, but it's kind of like fading in and out. So if you could stay close, I guess that'd be great.
Okay, I'll do my best. Chief Staley outlaid it correctly. Sorry, it's kind of difficult too. It's cutting out even here.
I think he's trying another mic.
Is this one any better?
It seems to be, but go ahead and go forward.
Okay, Chief Staley outlaid it correctly. The court has approved the settlement with Morgans. On December 11th, we have a hearing in the district court for approval of the second stage transaction, which is a corporate reorganization under Chapter 86. And we would ask that the board follow Chief Staley's recommendations, that the board approve the first stage transaction right now, as well as the second stage one to 800 Stillwell, subject to court approval at the December 11th hearing. I'd talk more, but I don't think it's doing anything.
All right. Questions by the board? There were a couple of oddities in here. They weren't really of major concern. We have some transfers going through, going to propose eventual landing spot. Is that going to be the name, or the name's going to be determined as to how they operate on a later date if we know at this point? And if not, we'll wait till that's provided to us. The other, and it seems to be something that's going back and forth, and the settlement agreement kind of takes care of it, was some concerns as to financial information, but the parties involved seem to be working that out. And it's not a concern for our staff at this juncture. And the last thing, I take it that our owner is also the sole owner of Tico Construction. There's no other partners involved in that.
I'll speak to the landing spot, Mr. Chairman. Oh, go ahead, Mr. Humphrey.
No, go ahead.
So as far as the landing spot, the ultimate landing spot is going to be an entity called Stillwell, 800 Stillwell. The end term is going to be still a new leaf entity. Once approved by the court, though, however, it would be transferred and subject to them to transfer it to the 800 Stillwell entity. Correct. That's right.
With that, any other board member have any other questions or concerns as to this, or if they're ready to go forward with it? Hearing no questions concerned, can we have a motion?
Mr. Chairman, this is Member Nylander. I would move for approval of item 5C, the TOI for new leaf cultivation. And that would be conditioned that the transfer occur upon the court approval that's pending for the, and I guess it's technically called the receiver. I think it's, I would characterize it as court approval and any other necessary approvals that might be required, just to make it a broader condition.
And Member Nylander, there's two steps. The first step, you could fully approve of the transfer to Mr. Hose. And then the second step to Stillwell would be a conditional on court approval.
Yeah, so the transfer would be,
sense?
yeah, no, it does, Mr. Rath. Thank you for that. Yeah, so the transfer of interest would be approved now, and then subject to the Stillwater transfer, subject to court approval or any other necessary approvals.
With that clarification, we have a motion on the floor for approval. Do we have a second?
Member Young, I'll second that.
It's been moved and seconded. Any other discussion or clarifications? Hearing none, all in favor, please say aye.
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 Matter carries unanimously.
Thank you, and we appreciate staff's hard work during this application process.
And So kind of like while we're here and while we're standing up, it goes to item number 6, consideration of approval to remove cannabis receiver over a New Leaf Cultivation Center LLC, C089, RC 089, and New Leaf Production Center LLC, P0 058 for possible action.
Thank you, Chair Douglas. L. Christopher Rath, Senior Deputy Attorney General. I'll be presenting this item. This agenda item really flows naturally through the last item that Mr. Staley handled. As you recall, the New Leaf entities originally sought the appointment and placement of a receiver due to ownership disputes. With the court's approval of the TOI and now CCB approval of the TOI, one of them being conditional, that ownership dispute is now resolved. As a result, there's no further need for a receiver over these licenses. The receivership court has approved the party's stipulation to remove the receiver subject to the CCB's approval, and the court issued an order to that effect on November 4, 2022. That order indicated that the receiver is removed once the CCB has approved his removal. CCB staff sees no issues with this removal, and same parties are here for any questions you may have on that. So the vote here is simply to remove the receiver from the licenses.
Representations.
Thank you again. My name is David Edelblut, counsel for the receiver, Dotan Melik, and he's appearing by Zoom. He's out of state.
And yes, Ed Humphrey on behalf of Alex Hose and 800 Stillwell LLC.
Need to have you speak up, please.
The microphones are useless here, sorry.
We got that part good.
Somehow that came through clearly, so.
And it's really loud in here, so I don't know what you guys are hearing there. It is Ed Humphrey on behalf of Alex Hose.
Any board member have any additional questions or comments since we're having little microphone issues?
Mr. Chairman, this is Member Nylander. I do have I don't have a question. I just have a comment. And you, please correct me if I'm wrong, but these last 3 transfers of interest, where there were no areas of concern identified by staff. And in this item as well, no areas of concern. I don't think since you and I have been initiated this board, I don't think we've had any agenda where we didn't have any areas of concern on transfers of interest. So I want to just reach out and say to the industry and their counsel, thank you. Like that's where we're trying to get to is, even though there were a bunch of, big business disputes going on that led to these transfers, but they were all clean. And I appreciate that. I think that's what's in the best interest of the state and the maturation of the industry. So that's just a quick comment, and I'm prepared to support this application.
Likewise, noting what was attached to both motions. We have orders that have been signed by the court. The court's also taken into consideration the various approvals that are needed by the various entities from our board to other entities in their contemplation. And more importantly, for the most part, necessary background information has been provided to this board, and that's appreciated. It makes our job in the investigation of the department much easier and gets things resolved swiftly. So with that, can we have a formal motion for approval of this matter?
Mr. Chairman, this is Member Nylander. I would move to approve item 6 as stated on the agenda to remove the receiver.
Thank you. Do we have a second?
Member Merritt, I will second that.
And moved in second for approval of removal of the cannabis receiver over in Beef Cultivation Center LLC 089 and C08, 089 and P058. With that, motion with a second. Any other discussion? All in favor, say aye.
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 Aye. Carries unanimously. Thank you. Thank all the parties on this. I'm going to real quickly
Thank you.
move over to item 8, and I'll come back to item 7. It's just consideration for approval to extend final inspection deadlines.
Good morning, Chair, members of the board. Steve Gilbert, Chief of Administration for the record. I'm here today to present agenda item number 8. Excuse me, I think we're still having some, are you guys able to hear me in Las Vegas?
Yes, still breaking up, but we can hear you.
Okay, I'll do my best to stay close to the mic. I'm here today to present agenda item number 8, which consists of petitions submitted by conditional licensees to extend the deadline to receive a final inspection by the CCB. Agenda item 8A is for Forever Green LLC. Forever Green LLC applied for and was issued a provisional cultivation license on November 3rd, 2014 by the Division of Public and Behavioral Health. It was issued a conditional adult use cultivation license on September 11th, 2018 by the Department of Taxation. Both licenses were issued in the North Las Vegas jurisdiction. Forever Green was issued its medical final licensure on April 2018 and its adult use final license on May 1st, 2019. Forever Green vacated its cannabis facility in November 2019 due to landlord-tenant issues. On September 1st, 2021, the CCB issued a notice to Forever Green. The medical and adult use licenses were being reverted to conditional status because it did not have an operating facility. Forever Green was also informed that its new cultivation facility must be inspected and approved for final licensure by the CCB and complete appropriate local government requirements no later than September 1st, 2022.
You still with us?
Yeah, I'll try a different mic to see if that helps. On August 19th, 2022, Forever Green, through its legal counsel, submitted a request for an extension of the September 1st, 2022 deadline. In its request, Forever Green reports that the COVID-19 pandemic has affected its ability to meet the September 1st, 2022 deadline.
I can't hear. I'm sorry. Hello, I cannot hear you on that mic because it's not loud enough.
What we're going to do, we will take a short recess, hopefully 5 minutes, see if we can get our mic situation straightened out. I was hoping to get through these 2 items before we take our bigger item, which we would have taken a recess to make sure the mics were working properly. Let's take a 5-minute recess. It's about 2 minutes to 11, so we'll start back up at 5 minutes after.
These are
Right? And we put my phone on the Zoom. Yeah, and I'll just go headphones Zoom and like get right? I do.
We're trying.
Testing. We're gonna go now. Can you? Testing. That's not gonna work. Nope. That was your idea. That was your idea.
Okay, so we have an echo chamber effect.
Yeah. It's not gonna go in by the word. No, we got an echo chamber. Steve, will you unlock and disconnect from the meeting?
Yeah. That goes.
Yes. Yes. Nothing. No. You put this one back. You want me to try a different one? Testing. Testing. Do you speak directly into the
How about now?
testing, testing, testing. I think it's better.
Okay.
Las Vegas, can you hear us okay? Las Vegas, can you hear us okay?
They need a minute to unmute.
Okay. We think they're unmuting now.
Yeah, this is member Nylander and I can hear you great. It's way better, way better from.
Thank you. We appreciate everybody's.
Morgan, this is Tyler. I can hear you as well. Can you hear us?
Yes, sir. Everything is a lot better. Thank you.
Yeah, it sounds a lot better. All right, thanks.
Yeah, we're back on the record, and I apologize for misstating the time, but I'm looking at the clock in the back of the room that didn't fall back. So we hear it's about 12 minutes after 10, not 12 minutes after 11. Having said that, we'll come back we were at item number 8, consideration for approval to extend final inspection deadlines. We were hearing representations for Forever Green LLC. If we can have that continued.
Thank you, Chair. Thank you, Chair, members of the board. Chair, would you like me to start from the beginning? I'm not sure how much you heard down there, the first part.
I think we got part of the first part. Let's just kind of continue where you left off, and if we have questions, we'll come back at it.
Yes, Chair. On August 19th, 2022, Forever Green, through its legal counsel, submitted a request for an extension of the September 1st, 2022 deadline. In its request, Forever Green reports that COVID-19 pandemic has affected its ability to meet the September 1st, 2022 deadline due to a disruption to operations, supply chain issues, and other delays. As a result, Forever Green reports it has not been able to secure and open a new location to convert their license from conditional to operational status. Forever Green supplied a timeline of events and efforts to secure a new location to support their request for an extension. The timeline reports working with multiple real estate agencies since February of 2021 to locate and lease a suitable location in North Las Vegas jurisdiction. Staff have communicated to Forever Green that there are no areas of concern and have asked the licensee to be prepared to discuss its progress at the board meeting. I'm available for any questions. Paul Murad is present today to give a brief presentation and address any questions you may have as well.
Good morning.
Yes, good morning. Paul Murad on behalf of Forever Green LLC, and everything has been said very succinctly, but I'm available for any questions that you may have.
Well, the real question is, where are you guys at in the process? I know you've had some problems in the location, the area that your license is good for. What are the prospects of going forward with the venture?
Sure. Well, it started with issues with a very unreasonable and difficult landlord that created a lot of problems, much like, well, although without knowing all the details, but you've heard other issues with landlords. And then there was also another matter with the management agreement with a party that was supposed to, that had a managed services agreement that got entangled on its own side in litigation and entangled the company as well. So we're waiting for that to be worked out and resolved, and it has been. There's indications that it's been resolved from that party that had a managed services agreement that had entangled our company and put it at risk of being entangled in the matters that were not created by us, not related to us, but related to a party that we had a managed services agreement with. And then as far as the timeline that we presented to the staff, indicated that we'll be able to get it done. This was 3.5 months ago, our matter that when we started talking in August. So we were asking for an extension, I think, till March. And we would need ample, the same amount of time just to be able to secure a location. Now that the litigation that we were entangled in, again, just by being frivolously named, we believe, and our attorneys believe, is nearly resolved. We should be able to get it done in 6 months.
Do you have any, without getting into details of locations. Do you have location prospects in mind at this point that you're in negotiation?
We have several that we had started discussions, but didn't want to progress too far. You know, people don't want to get too serious in discussions when, especially with this matter of extension, with also a question as well.
Other questions or concerns by board members?
I have a question about our process. I don't think we have a process, am I correct, to when a license goes to conditional status and then goes back to final status to review their financial suitability and kind of check back in with them after they've been inactive, right? We don't have that.
As part of
Gilbert for the
the
record.
extension request, that is not part of the extension request, but it can be if the board wishes to see that review.
I think I would suggest that we should look at something like that. If we have a situation where a licensee is kind of fledgling along and or limping along, then they become inactive, and then it's kind of just a piece of paper right now. I think we should look back into, well, the same as we would a final, the initial license. Do you have the financial suitability to open up? So I would suggest that we condition the extension on going through a financial review. And it doesn't have to be complicated, just the finances that we'd look at for like a transfer.
So, yeah, this is Member Nylander. I agree with Member Durrett. I think we need to take a look again. These are kind of unique. I think we've gotten through most of these extensions. But for Mr. Gilbert, I think a question is, so we have two of these on today. What is the date that is best for you as staff to be able to, because, you know, we had a bunch of these that were February. So I'd like to get Mr. Gilbert's comments on what is the appropriate date for this one. And I'm sorry, Mr. Chairman, not to take it out of order, but we have another one. And I'm thinking they should be the same, maybe. I'm not sure. So for Mr. Gilbert.
Thank you, Mr. Member Nylander. Steve Gilbert for the record. Yes, so the last extension request period that we went through, all the extensions were for the most part granted until February 5th of 2023. And that worked out very well for staff, not only to manage the expiration dates of them, but also manage the workload that would be coming up during that time period. And at the previous board meeting, the board granted extensions to November 5th of 2023, which would work well for staff to manage that workload also.
Okay, thank you for that. Yeah, and I didn't have any other questions, but I would be prepared to support the extension through November 5th, 2023, with the condition that they provide updated financials for the staff to review before we, you know, so it can be on our agenda if it comes up again. You know, yeah. So yeah, I'll leave it to Member Durrett, but I do agree with the notion that we should review their financials, even if it's just administratively, and we get something back from the executive director, you know, that they meet the, you know, the criteria.
Any other comments? From my standpoint, the devil's always in the details. As indicated, each item is slightly different. We're, because of the various complications in the area, as well as with the management servicing group, this group has been really set back in terms of what we're attempting to do. Whereas the one we'll get to next, they're in a different posture. They're moving along, and at least the representation is like 90% of their way. So a little different, but the financial information is always helpful. So with that, as to this, do we have a motion for the extension.
Member Durrett, I move to approve the requested extension. The final inspection deadline would be moved to November 5th, 2023, in consideration of agenda item 8A. That would be conditioned upon a submission of financials, and it would be sufficient for it to be an administrative review and a report to the board that there were no concerns.
Thank you. We have a motion. We have a second.
Member Young, I'll second that.
Been moved and seconded. Any additional discussion? Hearing none, all in favor of the extension, please say aye.
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 Matter carries unanimously. Thank you and good luck. That moves us to Harvest of Nevada LLC. The C205, RC205, and P136, and RP136 for an extension.
Thank you, Chair. Thank you, Chair. Steve Gilbert for the record. Agenda item 8B is for Harvest of Nevada LLC. Harvest of Nevada LLC, or Harvest, was issued a provisional medical cultivation and production license on April 11th, 2018, and conditional adult use cultivation and production license on September 7th, 2018, within the West Wendover jurisdiction. On December 20th, 2021, Harvest, through its legal counsel, submitted its first request for an extension of the February 5th, 2022 deadline. Harvest's request went before the board at its January 25th, 2022 meeting. The board granted an extension to Harvest's provisional and conditional license to February 5th, 2023. On October 11th, 2022, Harvest submitted a second request to extend the February 5th, 2023 deadline for final inspection of its provisional and conditional licenses for 12 additional months to February 5th, 2024. In its latest request, Harvest reports site work is 90% complete and provided supporting documentation showing their progress. Harvest now awaits insurance on the building permit in order to start pouring concrete pads and commence construction of the building. Staff have communicated to Harvest that there are no areas of concern and have asked the licensee to be prepared to discuss its progress at the board meeting. I'm available for any questions, and Alicia Ashcraft is present today to give a brief presentation and address any questions you may have.
Good morning.
Good morning, Chair Douglas, members of the board. Alicia Ashcraft, the law firm of Armstrong Teasdale, on behalf of Harvest of Nevada. Happy to answer any questions that you may have. Just to iterate what Mr. Gilbert just stated, they are 90% complete with the site work. One of the significant issues now is that the ground is simply too cold to pour the pads to start construction. So we're a little, no pun intended, awaiting the spring harvest for the ground to warm up so that we can pour the stable pads and then commence construction. I would also point out two things, and one addressing Member Durrett's possible condition on this item. The work was really performed under a management services agreement with a potential buyer, Vertical Horizon. And Vertical Horizon is in the last stages of its TOI, transfer of interest application. I would expect that to come before the board in the next couple of months. All of this to say that the financial review to which Member Durrett was referencing should be covered when that transfer of interest is completed. I, of course, would have no issue with that being a condition, but would just ask that it be noted that if, in fact, the transfer of interest is completed and goes forward before the extension is up, that financial review would satisfy that requirement. Again, happy to answer any questions. We did ask for a 12-month extension, but completely understand and would accept the extension to November 5th, a 9-month extension for consistency's sake and administrative reliability. Thank you so much.
Thank you for that statement. The last part goes to the first question I was going to ask out of the box about the continuation date. Just to making it easier, life easier for having consistency in dates at the November date opposed to the dates you're requesting. Looking at the report, one of the things that always is a concern is when we have concrete has not been poured yet, and hopefully there's no problems since it states awaiting issuance of building permits in order to start pouring concrete. And as a side note, having flipped past the football game at UNR last weekend and seeing snow coming down and the players playing in the white fluffy in Reno, yes, it is cold up there. With that, unless board members have any other questions or concerns, the conditions of administrative, financial, and hopefully it will be more than just it'd be a nice updated report in November that they're going to get it done. Can we have a motion?
Member Dret, I move to approve the request for the extension for agenda item 8B. The new deadline would be November 5th, 2023. And the TOI that they were discussing would satisfy that administrative review. Is that what you had in mind?
Well, depending on where it is in posture of what we need.
If you submit it with the TOI request, that would be sufficient.
I would have no issue with Member Dredd, if I may, with you putting the same condition that you did on the last item. All that I would ask is a notation that because there's always a chance that the transfer of interest isn't completed, falls through, doesn't get approved,
Yeah.
that go ahead and put the condition on as you did before with the notation that if the transfer of interest is completed, and we can of course note that on the record when it does come before the board, that would satisfy the financial requirement if it's actually completed. Because what you asked for is the same type of financial review that Chief Staley would be doing already on the transfer of interest for the new owner that's completing the facility anyway.
Right. So the condition would be to submit financials if they haven't already been submitted by then.
Fair enough.
Mr. Staley, does that work for you?
Mr. Chairman, David Staley for the record. Yes, it does. Member Durrett, on these types of TOIs where, we have a proposed acquisition that's covered by the management services agreement, we will typically include a brief summary of what was done under the management services agreement. And because the entity under the MSA will be the new proposed owner under the TOI, then it would be appropriate to do the financial review of them at that time. So I think we'll be able to provide everything that you're looking for.
Thank you. We have a motion on the floor. Do we have a second to that motion?
Mr. Chairman,
Second.
I just have a quick comment.
Fine.
And I'm in agreement with the motion. And Ms. Ashcraft, I want to thank you for providing a thorough, background of where the best efforts have been for the applicant to, but Mr. Chairman, should we condition it that the temperature be above 32 degrees in West Wendover?
I don't think the legislative group gave us that authority.
I agree. Thank you.
With that, we have a motion. We didn't get our second. We had dueling people going forward with the second on the record. Do we have a second?
Member Merritt, second.
Moved and seconded. All in favor, please say aye.
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 Thank you so much.
We have no nays, so it's approved unanimously. Now we come back to item number 7, petition filed pursuant to NRS 678A 461D, Sahara Cannabis Coalition petition to request amendments and/or additions to regulations 1, 6, and 10. What I would like to do on this one is have Mr. Adler, and I have a question for him at the outset, give him an opportunity because he started to speak in terms of his present relationship, clarify the record, then talk about his petition, give our department an opportunity to comment in terms of their questions and concerns at this point. And then we'll open it up to comment from parties from the industry, because I note we got something like 46 pages that came in last night, both pro and con, pro, con, and agreement. So we're kind of all over the map depending on what issue. It is a very important issue, the board recognizes. So with that, Mr. Adler, would you like to lead off?
So I was informed audio might still be an issue up here, so let me know how it's going on your end. Am I audible and clear down south?
No, you're not. Morgan, are you still there? We could hear you before, but we cannot hear Mr. Adler.
Okay, so if I speak up, maybe, or get closer to the mic, or
we can hear.
Switch mic.
Testing, testing. Are you able to hear me on this one?
Yeah, I think that's a little bit better.
Can you hear me now? Well, it looks like maybe yes. Get right up on this microphone here if that works. And well, okay, let's try this and begin. I'm Will Adler. I'm presenting this petition on behalf of my firm, the Silver State Government Relations. We are representing the Sierra Cannabis Coalition today. My comment that I began the meeting with, or I began my comment at the beginning of the meeting with, was that I previously did work with the Scientists for Consumer Safety, a laboratory coalition here in the state of Nevada. My relationship with them was one that I did for years with a coalition of Nevada cannabis testing laboratories. I was just going to state that my association with them has come to an end, but some confusion has come forward whether I did still represent laboratories within the Sierra Cannabis Coalition, which we do not. So that was just my general comment at the beginning. Hopefully, I'm still audible and clear, and I can continue.
All right. Before you proceed to the petition, and I'll make the statement, and it's my position. In the future, Mr. Adler, because you were asked a question in terms of who your group is representing, you told us parties were concerned about possible retribution by the board. We are concerned with that statement. By statute, your party normally would not, you as a party, you're not a party. You don't fit the definitions. So we need to know who you represent. Based upon the letters I've gotten back and forth, we have a number of interested parties. We'll go ahead with what you've presented. But in the future, when you wish to come before the board in this fashion, you need to state to us who you're representing, so we and the other public parties have a better understanding of who's involved, what the representation is. If there's some concern about the board being heavy-handed one way or the other, we're not aware of it. We're just trying to do what we can do to make this stuff work. Having said that, I'd like to hear what your request is for changes as to these items 1, 6, and 11.
Okay, excellent. Thank you for that comment, Chair Douglas. Again, I'm Will Adler, and I'm the Director of Silver State Government Relations, and we are representing the Sierra Cannabis Coalition. The Sierra Cannabis Coalition is a coalition of Nevada cannabis license holders, particularly vertically integrated groups with multi-state operations and in-state operators that are solely cannabis cultivations and cannabis cultivation production facilities. And at this time, I don't represent any laboratories or in any way. I want to make that very clear on this. But I've been made aware of their comments and sort of their positions on my petition. So if it works for the board, I will go through the petition at this time and some of the top line thoughts for why we're filing this petition and sort of the intent for what we're filing today. So the Sierra Cannabis Coalition took a top-down view of Nevada's cannabis testing policies and sort of their origins and longevity of why we got here. Nevada is well regarded as the gold standard for cannabis regulation nationally. Our testing policies have been such since the medical marijuana days, and sort of were established under a group called ILAC, which was this subgroup of policymakers for specifically laboratory issues back under the medical marijuana program. Back then, Nevada was on the cutting edge of cannabis regulation. We in fact didn't have any other states to look to for final regulations when we had to establish our own testing regime, because at the time we didn't have anywhere to reference what is the appropriate way to test cannabis, because cannabis was federally illegal. There are no established parameters for pesticides, heavy metals, or any food-based testing parameters around it because of its federal illegal status. All other testing parameters are based federally around guidelines for food or pharmaceuticals or cosmetic products have their own testing regimes that are sort of established. Nevada had to establish our own. So we established them based around the best practices at the time, or what we thought could be the best practices, which was establishing a 5-pound lot based upon essentially what other states were doing at the time. Colorado was packaging up lots individually at the time, and we wanted to do likewise. In this practice, though, we did establish just sort of a baseline for this is a lot that comes out of a batch and it can be tested as such. Going forward with time, though, other states and other regimes have established, what are best practices in those states. And the Sierra Cannabis Coalition and some of our members do operate in those states. It's bringing forward a general petition to Nevada to ask maybe not to do exactly the changes that are brought before you, but look at our testing regime, how it's established, and what changes could be made to maybe make beneficial changes going forward for everyone. But the core of the issue is around what is a batch and what is a lot here in Nevada. So going through our petition more precisely, Nevada set up a regime, like I said, originally where we established a batch must be a cultivator's establishes a part of their room or essentially part of their facility that has a single strain grown at a single time. They'll be harvested by a single harvest date. That harvest date establishes what will be called a batch within a cultivation. Essentially, though, the definition for lot in Nevada references batch, and the reference for batch references lot. So batches can be of this quantity, unstated, that can be harvested at a single time that must be broken down into individual lots. The issue here is lots are only subjected to being 5 pounds at a time. When it comes to the processing of a cultivation, you are to harvest your batch at a single time, but you then have to establish it into these separate lots. That takes man hours, it takes metric reporting time, it takes tags, and it takes a real relationship with your lab to get this done. But it is one that is needlessly done because in a lot of ways, the batch is already the known quantity of cannabis produced by that cultivator. It's established at the same time, is grown in the same environment, and it is of a single strain, and it needs to be tested essentially as the same product. The idea of breaking that batch down into subcategories of lots is understood, but the idea of having it as a fixed 5-pound lot is the question here. So Sierra Cannabis Coalition, asks our members, what is the best practice in other states, or what have you seen, working in other areas? And generally the response was increased flexibility. So we didn't want to say, the minimum lot size would be 50 pounds, but we did want to say there needs to be an increase to the lot size to encompass that batches usually end up being larger than a 5-pound lot. A batch frequently is 7 pounds, it's 12 pounds, it's 17 pounds, right? But to break that down into a lot today, it is breaking it down into multiples of the same batch. Essentially, the batch, it doesn't change itself. The cannabis itself in that batch is the same, but you break it down into individual lots for testing. But upon perceiving a test of pass or fail, usually pass, thankfully. Most cultivators reprocess those lots into a single batch again and sell it off en masse to dispensaries with essentially no, acknowledgement for why the lot was necessary. Right? We had to separate into 5 pounds, identify that it did pass, and then we put it back together and say, hey, how much do you want? 10 pounds. Well, put those lots back together in a single batch essentially, and sell them on to down the chain. So the premise of it is additional flexibility creates the workflow status that the cultivators are seeing in other states. They're able to say, hey, this harvest is done at this time, ask for testing, dedicate this amount of resources, and go. Here in Nevada, it just adds that additional step to break it down into additional lots. So again, we've asked members what flexibility provided by 50 pounds is there for, lots of flower and of trim. Well, again, trim is essentially usable cannabis product. It's the same as usable flower. So the idea of having a trim at 15 pounds where we up to lots to 50 didn't make sense. So we added 50 pounds for trim, 50 pounds for lots, because it says whatever that batch is, feel free to use your own dedication as a cultivation to say, I'm asking for this amount of a lot to go forward. The counter response from a couple cultivations was, we are concerned that having a 50-pound lot or adding multiple lots together, so whatever multiple it ends up being, creates a larger possibility of a failure, right? If we do have a failed product out of a larger lot, we are essentially, deeming more products for secondary remediation, or they have to be deemed for extraction at this point. They are a loss to our company. And they said that they might not actually take on a larger lot size at this time. Their companies aren't structured that way. They grow it continuously at around 5 pounds per strain, and that they thought their lots wouldn't be increasing substantially or at all. But again, they said that added flexibility would be great, because sometimes the harvests do come in at 6.5 pounds, and that pound and a half still has to be tested. And it would be great if they could just bump it up to 6.5 pounds instead of the flat 5 pounds. So that is essentially why we went to NCCR 1.125 and changed those two definitions. Equally with production run, the same language is found in Nevada for almost the exact same reason. We established our testing policies at a very early date, and at that time, it wasn't known what would be the best policies across the country. We even thought maybe the metric system would be the best system there. So Nevada established a production run and sort of a limit to what a production run could be based around a 1 kilogram limit. So 1 kilogram comes out to be 2.2 pounds. So the Sierra Cannabis Coalition looked at production runs, and it says, essentially, you must limit your production testing to 2.2 pounds at a time. Nevada is the only state nationally that limits production runs at all. In any other state, it is whatever your full production cycle can produce at a single time. So load your machine up with as much flower as you can, go through a single cycle, which is usually a 12-hour cycle. The amount of product that produces is what is tested everywhere, because the product that comes out of a machine after it's loaded, completely, goes through a full cycle, is a uniform product that comes out the other side. There's no separation of these 2.2 pounds are separate from that, excess material. It is simply whatever comes out of the machine is already a uniform product and is already considered having gone through the production run. Hence, it can be used for, secondary extraction. It can be used for products that have already failed as remediation, because the known aspect of production is it does this uniformity and it does this single cycle process. So again, Sierra Cannabis Coalition looked at this as not a failure in Nevada's current testing system, but a question of why would we limit it to 2.2 pounds? If some machines can produce more than that, let them test the whole process that comes out the other side. If other machines can produce less than that, so be it. But the idea that limiting it to a fixed number or a weight under NCCR 1.165, again, didn't gel with workflow and actually ability to process things smoothly through your facility. If you're stuck waiting for your machine to run, and then weighing the outflow to divide it up, it just creates steps that add no safety and no assurity to the actual test itself. So Regulation 6, though, we asked members what's a big thing that is done in other states, or what do you think needs to be done in Nevada to, again, streamline the process and get down to what needs to be tested and where testing is most effective or not. One of the biggest complaints or concerns was today in Nevada, we do segment of testing in a regimented way where you must have a test either passed or failed before you can go to the next step. And that, it did make sense at the time. Again, establishing the regulations at the time, which have continued over this day. Nevada created a vertically integrated system where we can sell products from one cultivation to another. We can sell products from a cultivation to a production facility, or from a cultivation to a dispensary. But in the early days of marijuana growth and industrial use of marijuana here in Nevada, we had a lot of questions about what would be needed in the workflow process for someone to buy cannabis from another cultivator, or buy cannabis as a production facility from a cultivator, to have a surety of that product before they finish a production product. That created a system where we end up testing products several times at each step, when ultimately the consumer only really needs that finished cannabis product to have the test. So today in Nevada, you can have a situation where a cultivation has cannabis flower tested that fails. That flower is then deemed ready for remediation. They can have it sent to remediation and juiced in a machine. It must be tested again as a base product when it becomes an oil after it's gone through a production cycle. That test passed again, then is sent to, half of it goes to an edible and half of it goes to a vapor cartridge. That cartridge test is a second test as well. And then the edible needs another test to declare that is, again, a safe product for consumers. Whereas in some states, it is simply an attestation or a write-off, as in Washington and other places, where as a cultivator, I'm selling you this product without a test, and you as a production facility are receiving it because you're deeming it for extraction. They can then extract that product and only test whatever comes out the other side when they deem whatever the final product will be. I don't know if that is exactly the right mechanism in Nevada, but it does get to the core of when do we need a test on a cannabis product? And the Shares Cannabis Coalition members put forward a pretty good stance that consumers do only need that test on a finished cannabis product, because every test subsequent to that is an identifying test on a cannabis product. But the finished cannabis product is the one that the consumer ultimately consumes, and that quality assurance test is the safety bar that assures everyone that they are getting the product they think they're getting here in Nevada. So that is why we did just delete a section of NCCR 6.100 that said a lot of usable cannabis and concentrated cannabis, because honestly, it is just a cannabis product that the consumer gets to, and finished cannabis products, or cannabis products in this case, are the only thing that need a test. Going to Regulation 11.045, there was a small addition to R&D testing when the CCB came into existence. We essentially took all the regulations that were in place under taxation and reissued them under the Cannabis Control Board. Section B of 11.045 was added when the CCB came into existence, and it was just simply a line that says you must receive approval from a board agent to do any R&D testing. Again, this is sort of just a mechanical step where we must ask for approval of testing to do R&D testing, when research and development testing is really an internal process that should be flowing back and forth very smoothly. And today, not a lot of people utilize research and development testing because it is a little clunky, it is a little harder to do, but it is one where I think people should utilize it more, and testing companies should be able to do more of this testing. So just that line of asking for board approval does slow down the process today where we have to wait for a reply from a board agent, which can take, a couple days sometimes. So just removal of that because it doesn't seem necessary at this time. And that is the core of the petition proposed by the Sierra Cannabis Coalition.
Thank you. At this point, I'd like to hear from either Mr. Rath or if we have Ms. Cronkite, whoever is going to make the presentation.
Thank you, Chair. L. Christopher Rath, Senior Deputy Attorney General. I'm going to provide you first with a summary of the CCB staff's concerns. Ms. Concrete may add to that, or she may have further detail than I have on any questions you may have. First of all, I think the overarching concern here is adopting this as written currently is problematic. This is an area which needs further analysis, further study, input from others in the industry, apart from the Sierra Cannabis Coalition, and possibly a workshop to really flush out the scientific details and the pros and cons of what's being asked for here. Also concerning is something you alluded to, Chair, and that is who is the Sierra Cannabis Coalition? Is it one cultivator? Is it no cultivators? Is it 20 cultivators? We don't know the number of people out there who are looking for this change, and that is concerning as well. As to the proposed change to NCCR 1.125, such a large increase in lot size, up to 10 times now for flower, will increase the risk of inaccurate test results due to greater chance that microbials could be missed. Microbials can be scattered throughout the batch, and across the lot, and if the lot size is very large, it increases the chance of missing microbials, such as even salmonella. The labs would need to collect a greater sample size and may need to run multiple tests in order to ensure the results are accurate. Additionally, if the sample fails testing, then an entire lot may have to be destroyed, which would result in destruction of much more cannabis and cannabis products than under the current lot sizes. Based on those issues alone, there would likely not be much of any of a cost savings for the cultivators and producers. As to the proposed change in NCCR 1.165, this would eliminate any weight limit for a production run of concentrated cannabis. That would create the same type of problems with inaccurate testing as I just discussed with the greatly increased lot sizes. As to the proposed change to NCCR 6.100, this seeks to test only final cannabis products and would eliminate any testing for usable cannabis and intermediate cannabis products before the final product. Allowing for this would provide less information on the final product, as contamination sources are often detected in the initial raw cannabis or in an intermediate product. And some of the intermediate products can also be used as final products. Furthermore, not all failed usable cannabis may be appropriate for extraction, and you wouldn't know that unless the initial cannabis used is tested as well. The last requested change is to NCCR 11.0452B, which would eliminate CCB approval for requested research and development testing. Staff does not believe this is needed. There is a rapid turnaround time for CCB staff to respond to such requests, and it doesn't require much staff time. There would be little, if any, cost savings there. Also, allowing for staff review and approval of research and development can reduce the risk of lab shopping. You may have a situation where a cultivator simply goes and gets research and development from 9 different labs and picks the one that it likes the most for its results. There should be at least some justification for R&D testing. I understand the labs will like to be heard on these issues, and I understand they're going to be presenting their view as well. And would invite Ms. Cronkite if she has any additional details beyond what I've gone through, or to answer any questions. I'll turn it over to Ms. Cronkite. Thank you.
Kara Cronkite for the record, Chief of Inspection and Audit. I agree with everything that Deputy Attorney General Chris Rath just stated. I would just like to add on the topic of only testing final products. If there was a cultivator who knew that all of their products were going to go to production, for example, that would discourage clean and sanitary growing methods. There would also be a lot of inspector time utilized for trying to figure out who maybe was using illegal pesticides. If that popped up on a final testing product, we wouldn't know necessarily which cultivation facility was using those pesticides. So any source of contamination would be very difficult to pinpoint back all the way to the growing method. And also, without testing the usable cannabis, there's potential that cannabis that might be contaminated with salmonella or E. coli, which we do see occasionally, might make its way to a production facility which makes edible cannabis products. And I feel like the risk there would be very high, as that's a very pathogenic, as those are very pathogenic organisms.
Thank you. As I had said earlier, I'd like to hear from the folks in the field, the public that gave us 46 plus pages, pro and con. No specific order. The microphone's open to hear, at least initially, the thoughts.
Thanks so much, Chair Douglas. Members of the board, Alicia Ashcraft, the law firm of Armstrong Teasdale, on behalf of a few of the state licensed cannabis testing laboratories, one of which is G3 Labs. Dr. Tung is in the audience this morning as a representative. While I agree with Senior Deputy AG Rath's comments and would like to incorporate those, I'd really like to focus on the first of those comments, which you, Chair Douglas, highlighted as well. While we welcome the opportunity to discuss some of the seeming issues raised by the document filed by the Sierra Cannabis Coalition, we respectfully request that this board dismiss the purported petition and take no action pursuant to NCCR 4.145 sub 7A, as the petitioner does not have standing and the petition fails to satisfy the most basic requirements under that regulation. Namely, the document submitted by the coalition does not identify the name, business address, and telephone number of the petition as required by the regulation. By his own admission, Mr. Adler stated that the coalition is acting on behalf of its alleged undisclosed members. Such members, if they exist, would be the true parties in interest and should be disclosed as required by the regulation. If there's been some supplemental documentation filed within the last few hours before this meeting, those filings do not cure the infirmities of the petition. The statement and identity of the petitioner must be included within the petition that's required by regulation. The coalition states that it is a trade association acting on behalf of, again, undisclosed state licensed facilities. However, we would encourage this board to carefully research and determine whether a clandestine organization meets the interested party requirement of the regulation. The question of whether a person qualifies as an interested party has long been analyzed under the Administrative Procedures Act, but is generally held to mean evidence that the party has enough of a personal stake in the outcome of a controversy or matter so as to assure the clarity of the issues presented and the effect of the outcome in the determination. Essentially, it is a question of standing. Typically, the same standard as for determining standing to intervene is employed, and that is that the petitioner must assert an interest that is protected under some law or regulation, and there must be a relationship between the legally protected interest and the matter at hand. Since this board is not subject to the Nevada Administrative Procedures Act, it is even more incumbent upon its members to ensure the protections of due process as an exempt agency. The most crucial obligation being that the board must adhere to its own regulations, giving effect to each word and statement, and not arbitrarily disregarding certain phrases as superfluous or meaningless. We urge this board to safeguard this agency and its regulations against undue and potentially harmful influences. While we have no reason to doubt or question Mr. Adler in his intentions, the potential precedent that would be set by this board accepting and acting upon the coalition's petition is dangerous and unwarranted. It is the protection of the Nevada cannabis industry against these types of hidden and ulterior motives with which this board was charged. Again, we urge the board to dismiss this petition at this time and take no action until the infirmities may be cured and an appropriate analysis as to whether the petitioner may be properly considered an interested party under NCCR 4.145. I would also point out if they are indeed eligible, as there is a prohibition against certain parties filing under subparagraph 5. And I thank you for your consideration of these matters.
Thank you. Good morning.
Good morning. Good morning, Chairman, members of the board, Executive Director Climas. For the record, I'm Kimberly Maxton Rushton with the law firm Cooper Levinson. In the interest of time, I'll keep my comments brief. I'm appearing on behalf of RSR Analytical Laboratories, and in furtherance of my colleagues, Ms. Ashcraft's comments, I'll note the fact that I too believe that there are deficiencies with the petition, specifically as enumerated in the requirements under Reg 4.145. What I specifically complain about is the fact that the petition fails to identify all individuals or groups that could be potentially impacted by this proposed regulatory amendment. Obviously, this would impact the labs. There's no mention of that in the petition. And as you heard from staff, it could certainly impact both the consumer as well as patients who use cannabis in Nevada. What's important about this is the statutory declaration set forth in NRS 678B, which obligates all cannabis licensees to ensure the health and safety of the people of the state. This regulation will not meet that standard. So based on the fact that it fails to meet the regulatory standard as well as the statutory, I respectfully request that the petition be denied. Moving this matter into a regulatory workshop will not cure these deficiencies. The only cure for it is to deny it and ask him to come back when he prepares a ripe petition for your consideration. Lastly, I'd submit that this specific testing standard has been in place since 2014-2015. It was adopted originally or promulgated originally by the Department of Health and Human Services, then adopted by the Department of Tax, and then later by this body in August of 2020. As you heard from Ms. Cronkite, staff has worked on this specific matter with the intent of ensuring the protection and the health and the safety of cannabis consumers and patients. For that reason alone, this petition should be dismissed. Thank you for the consideration of my comments, and if you have any questions, I'd be happy to answer them.
Thank you.
Adam Fulton of the law firm Jennings and Fulton. For the record, Executive Director, Chairman, members of the board. I represent 4 laboratories here today. Ace Analytical is here with Dr. Bruce Burnett, and I echo the prior statements of the prior counsel for laboratories. And so I won't repeat their positions, but my clients agree 100% with what was said with them, for the record. In addition to their statements, my clients have major concerns regarding the lack of any science behind what is being proposed and what would ultimately lead to consumer safety violations. The following are a small subset of my clients' objections to the petition, and I'm going to try to address the science issues behind the petition that's being submitted. As one increases the lot size, it becomes increasingly difficult to obtain a representative sample for analysis. The reason for this is because of the incredible diversity of the different parts on the cannabis plant itself and the manner in which it is distributed within a lot. Under the proposed petition, it would be statistically impossible to obtain a proper representative sample for testing. This would dramatically jeopardize consumer health and safety. For example, if a cultivator has 10 5-pound lots, which when tested, 2 of the 10 fell, the product has been tested and the result is 10 pounds not being sold to the public, leaving the cultivator with 40 pounds available for sale. Under the new 50-pound lot system, under the current regulations, you would not get a representative sample and the lot likely could pass, and the 50 pounds of unsafe cannabis could then be sold to the public. Alternatively, a laboratory could pull 1 or 2 samples and have contamination, and the entire 50-pound lot would fail. In states where larger lot sizes are allowed, many samples are required to be taken within a given lot. For example, the petition gives a completely erroneous impression that the state of Washington tests 1 sample obtained from a 50-pound lot. However, Washington requires 19 samples from a 40 to 50 pound lot be taken pursuant to WAC 314-55-101. If adopted, the petition would require labs to directly violate many other NCRR regulations and standards to which they currently adhere, including but not limited to their ISO IEC 17025 of the International Organization for Standardization, Cannabis, Inflorescent Standards of Identity, Analysis, and Quality Control as published by the American Herbal Pharmacopoeia, recommendations for regulators, cannabis operations from the American Herbal Product Association, guidelines for laboratories performed microbiological and chemical analysis of foods, dietary supplements, and pharmaceuticals, and aid to the interpretation of ISO IEC 17025. It's from 2005 to 2015. The standards for good laboratory practices consistent with the OECD series on principles of good laboratory practices and compliance monitoring, in addition to violating the principles of testing established by the American Herbal Pharmacopoeia, the FDA's Pesticide Analytical Manual, and the Biotech Analysis Corporation, all of which, by the way, support Nevada's current testing regulations. Members of the laboratory community could discuss for hours the statistical and science-related reasons for keeping the lot size small if one wants to run a regulated, tested, safe market which protects the consumer and Nevada's reputation. The regulatory scheme and the SOPs developed by the laboratories in conjunction with the CCB have been developed over the course of 8 years. You must reject the petition or you will effectively unwind 8 years of work done by the CCB regulators and labs, which created the safest cannabis testing program in the nation. For these reasons and others too numerous to list, my clients oppose the petition. Thank you.
Thank you. Good morning.
Good morning, Chair Douglas, members of the board, Director Calamus. My name is Derek Connor. I'm appearing on behalf of MA Analytics, a Nevada licensed cannabis testing facility. They requested I appear before you today to note their concurrence with the issues raised by G3 Labs and their joinder to that public comment. And with that, that's it. Thank you.
Any other public comment here in Las Vegas?
Hi, good morning. Lake Martin on behalf of the Nevada Cannabis Association. We represent the majority of dispensaries across Nevada, as well as cultivation, production, and distribution licensees. We submitted written comment yesterday. It didn't look like it was included in the packet, so I wanted to make sure to register our comments here. We are in support of the petition, but it's clear that the petition has raised significant topics for discussion, both pro and con. It's worth noting that we are in the minority of states in terms of lot sizes, and it's worthy of discussion, obviously, whether we can increase lot sizes and to increase efficiencies and lower costs while maintaining safety. So while it's not our petition, we'd be happy to offer our assistance in bringing together labs and cultivation, production, retail licensees to try and collaborate and potentially find middle ground. And we would ask the board to consider referring the petition to a workshop, and we would hopefully facilitate a conversation in advance of any such workshop. Thank you.
Thank you. Anyone else in Las Vegas? Do we have anyone in Carson City who wishes to make a comment?
Does not appear that we have any public comment in Las Vegas.
Thank you.
Mr. Adler, do you want to comment?
I would like to comment, or at least, I don't know the process as the petition reply to public comments now that we've had them.
We can't hear you. And at this
Let me
point,
get up
Mr.
on this
Adler,
mic. You hear me now?
I can hear you now, but Mr. Adler, we're not going to take a rebuttal at this point.
Well, can I also give public comment then? Or I don't know, but I understand, but okay. My main comment was that, as the petitioner, I did meet with the director of the Cannabis Compliance Board. I asked for direction on how best to file this petition and in what way to file it. So I did receive that direction and approval prior to filing this petition. Obviously, I wouldn't have filed it without such prior, conversations. And I understand the concerns around filing the petition through my groups here at Cannabis Coalition. The merits of the petition are as they stand, and the request to go to a workshop is such because I do not believe these are ready for immediate regulatory approval. I don't have that insight, as it says in the petition. And it does state that, laboratory testing procedures, sampling, and other things must be adjusted or should be adjusted around a change that we've said. But through my conversations with the director and Mike Miles, it was clear that it is not my position to write all of the regulations in the state of Nevada, but to ask for the changes that we wish to see, and then for the CCB and maybe the rest of the staff there to go through a fact-finding procedure of their own, and to talk to the other states, as I've stated. I know the director is Director Tyler Klimas is the chair of the Cannabis Regulatory Association. I did envision the state taking a time to go out and see maybe what best practices would be prior to such a workshop, and do their own procedurals, because I do think a change of the sort we're proposing would require more downstream changes than I have written. But I wasn't to quantify those changes myself, or I didn't think it was appropriate for me to write out all of the additional changes needed around sampling and such, to be clear. Thank you very much.
Thank you. Comments by the board, and let me open the floor. This is not as a chair, but as a member of the board. We are charged with protection of the public and the industry. A misstep on behalf of the industry brings bad economic things to the industry, of people not wanting to buy the product here in Las Vegas, Nevada. So testing is something that is important for both sides. There are economic impacts, good and bad, but that's the nature of business, but they have to be considered. But the bottom line seems to be all that taken into consideration. What are the best practices? As indicated, we started this, 8 years or 7 years back now? We're in 2022 going to 2023. There's a little more material out there as to what the best practices are. For me, I don't know. I've read some of this material. Staff has provided us with some information. Clearly, in all fairness to everyone, we're not really, I don't think we're ready to go forward today. We need to really look at this and look at what other states are doing to get a good baseline. Mr. Adler, Ms. Martin, a number have spoken about, we need to kind of sit down and have a discussion. I, for one, I have some other things about what we do with this, but that's just my base comments about where we're at with this. It's important to the industry we take a look at this. What we do with it, that's a different story from my standpoint. Other board members.
I agree with you, Mr. Chairman. I don't know what, the best practices are. And as you said, we should always try to achieve, what are the best practices. But we've heard today and in the written materials, there's not an agreement on what that is. So it needs to have further discussion, and I know our staff is concerned about, the unknowns of the proposals, and there seems to be differentiations between what other states are allowing, and it drills even deeper in terms of not just the number of a lot or, a sample, but how many times do you have to test it? I mean, and those are things that I would have to have way more information on to make a judgment. So, but I'll await your comments on how you think we should handle, and the other members handle, this petition, because there is a legitimate, concern about whether it's deficient under regulation 4.145, in as much as we don't know who, we know Mr. Adler, he's appeared in front of us a number of times, and and I'm not even speaking about him personally, just, who is an interested party? Because we don't have a definition under the regulation of who is an interested party. So those are just my comments. I yield the floor to the other board members and you, Mr. Chairman.
Thank you. Other members wish to speak?
I have a couple questions and comments. Can I ask Ms. Cronkite, where did the 5 pounds come from? When I looked back, I could not find an actual source. And at the time, DPBH said it was a number that was arbitrary, which is going to be arbitrary no matter what. But do you have more insight into that?
I don't know specifically where 5 and 15 came from. I know a lot of our regulations at that time came from the American Herbal Pharmacopoeia. So I can check there and see if it's referenced anywhere. I do know we have reevaluated the lot sizes in the past multiple times, and due to the variability in the batches, we have chosen not to ever increase it because we didn't want to increase the level of variability from lot to lot.
So, but it kind of needs to be a balance, right? Because to make this as safe as possible for consumers, we should test every gram. So it has to be a balance between what's feasible and doable. Is that the right way to look at it? Like, we need a way, what would the standard be to base the decision on for what the largest safe amount would be? What data goes into that?
Kara Cronkite for the record. Yes, you're correct. Technically the safest way would be to test every single piece. However, what we've discussed a little bit here today, and I believe ACE Labs representative touched on, is a representative sample. And that's what a lot of tests for anything, they test representative samples. And so in order for us to increase the lot size, we would have to increase our representative sample that the laboratories collect. When they collect more product, the facility is losing more product that they have to give up for laboratory testing. The laboratory is having to run more tests to make sure they're testing all of that product. And again, if they fail, all of that product in the lot is a failure. And so we felt that by keeping it at the 5 pounds, it wasn't so limiting like testing every gram. However, it was an adequate amount to where it's not such a huge hit if it does fail. But I think that increasing the lot size, the laboratory fees, I can't say whether they would go down or up because they'd have to run so many more tests and collect so much more product.
So I agree with the chair and member Nylander that this is definitely a discussion that is ripe. We have 8 more years of information. Now a lot more states have come online, so we really should be looking at this issue. And a lot of the statements are that, the science supports this amount. This amount was based on science. This amount was based on the likelihood of properly achieving statistically valid sample analysis. Like, I haven't seen those numbers. So let's have that discussion and look at those numbers of if this 5 pounds really is the right amount. I mean, it's not in other states, in most other states. Just have a couple more questions and issues. I have a question for Mr. Rath. I don't know when an association can appear on behalf of its members. I know they can in court. When is the line drawn that they don't have, that they're not representative?
I think that's a line the board sort of has to decide to draw. I looked at the statute that allowed for these petitions and ultimately found it was taken from gaming. Looking at gaming, they did not have a definition for an interested person under their petition statute, but they did it under their declaratory order regulation. And that was pretty broad. It's anybody who might be impacted basically by the gaming statutes and regulations. So you could take a liberal reading of it that way, or you could take a more narrow reading. What we have here is someone purporting to be a consultant for some number of cannabis cultivators Is that enough to say he's impacted by Title 56 and the regulations? Maybe a stretch. It depends on how expansively you want to view interested persons. So that's kind of the background on that, if that's helpful.
I would probably be willing to go with whatever the board went with on the issue of how the petition should be treated. I think I completely agree that we shouldn't overlook parties not fulfilling all their requirements under that petition. But on the other hand, the board could bring this up on their own. And I believe it is a very widespread issue, and it has been for 8 years. It just hasn't, there have been other issues, and so it hasn't been taken up because there were other more pressing issues. I think it's great that issues like this are being discussed and that we have time to discuss them. Many of the previous directors of taxation would joke, cannabis is 99% of my workload and 1% of my budget. And now we have an entire body dedicated to looking at these issues and coming up with the best resolution. So I very much support looking at this issue going forward, and in what form I would defer to that. It might be premature to do a workshop, but I definitely think it should move to the next step. Thank you, Chair.
Member Merritt, Member Young, do you wish to weigh in?
This is Member Young. I guess more comment than question, and that, you know, it keeps being brought up that other states are doing it differently, but that doesn't necessarily mean they're doing it better. You know, most importantly is that we protect the consumer. I think there's a lot of great questions that have been brought up here that need further analysis in terms of the science for the lot size versus the positive and negative results. So again, I don't know if this is ready to move to the level of a workshop, but I certainly think there's been very good questions brought up today by Mr. Adler and also by the labs that I certainly would be interested in receiving more information so that we can move this forward and see if change is appropriate.
Thank you.
Well, I would definitely agree with many comments that has been made by other board members, but I also agree with our chair that this is not a decision that we can make now, that there is definitely more information and more research that can be done around the complete issue overall.
I had this written down, but I got scared and I didn't say it. Okay, the state policy is, of course, to protect the health of the public. That's number one priority. Nobody here, anybody in this room, anybody related to this industry is in trouble if the public is getting sick. But the public policy is also number one, listed as number one, the cannabis industry is beneficial to the economy of the state and the general welfare of its residents. So we also need to support the industry. I do, but of course, health comes first. But I just don't want that to get lost.
From my position, the object is not to kick the can down the road so we never get to it. I think it's important that we begin to open up this Pandora's box and look at it. I would be in favor of, from a procedural standpoint, dismissing the petition today. However, I would like to see us, if it's February or March, be in a position after our staff gives us some questions or asks for some comments to hold a workshop into February, beginning of March. So we can ask for some information, go out and begin to look at other jurisdictions. We were one of the looking material. Nevada was one of the leading jurisdictions, still is, sales and so on. But there are other jurisdictions who have now weighed in. Some have done science, some have just done practices or how they got put together. We're trying to balance best practices, protection of the public, and economic interest. We don't want to have best practice that drives everybody out of business because it costs too much. But we don't want to have no science that allows people or product users to get sick that destroys the industry because no one wants to buy our products. So my recommendation is to deny the petition, but as was asked for and voiced by some others, I think we do need to discuss this and to move it down the road, hopefully to be in a position in February, March to have some kind of workshop. But in the meantime, if we look toward having staff kind of formulate some questions to ask the industry before we have that workshop. So we come with kind of direction at that time. So we're not starting from scratch. That's my thoughts. If we have a board member that wants to rephrase it or put it in a different way or a different suggestion.
Mr. Chairman, this is Member Nylander. I couldn't rephrase it any better than you did. We definitely have a divide here between the petitioner and a bunch of other labs. So I would like to put it on them a little bit to get themselves together to sort of see if they can figure out, a compromise before they come back to us. And then, as you said, have our staff look into it further, because in terms of best practices, if we're not there, we should be looking at how we get there. But I don't think this petition is the right place now, because I don't think it, I actually don't think it meets regulation 4 qualifications. So yeah, I would be in agreement to deny the petition and then direct staff to start to drill more into the issue in collaboration with the parties, and hopefully the parties can, in the industry, meet even separately from staff and hopefully come up with some kind of compromise on these things, because we do want to have best practices, but based on the testimony and the documents we received, I don't know what those are. So that's sort of where I'm at.
Any other board member wish to weigh in, or we in a position to look at a motion? No one else is willing to weigh in on the record. If we can have a motion.
Member Durrett, I move to dismiss the current petition due to procedural deficiencies. However, this had surfaced an issue that the board would like to take under consideration, and we would like to see a workshop be conducted by the end of February or March.
I would second the motion.
We have a motion. We have a second. Any additional discussion? All in favor, please say aye.
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 No dissents, no abstentions. Matter carries. Petition is dismissed. We will have further work on this important subject matter. Thank you. That moves us briefing from Chair and Executive Director. Keeping briefings fairly short and concise from my standpoint. We received notice from Legal Aid Center of Southern Nevada that Legal Aid Center of Southern Nevada has a dedicated unit of attorney and advocates for cannabis and criminal record sealing. Legal Aid Center's Clean Slate Legal Assistance Program is now staffed for consultation and case representation to deal with those who have been, in essence, convicted of crimes that can now be sealed. So that's edification. The other is we just finished our elections. We have a legislative session coming in February. It's early yet as we start trying to figure out what's going to go on next in terms of legislature and the industry changing regs or not changing regs. But that's something that's on the Ouija ball.
Well, Chair, I didn't have something and then now I do. Just to follow up on the petition and the staff's task with this. I heard the NCA, Ms. Martin from the NCA represent that they would be willing to host some kind of conversation. Kind of piggybacking off Member Nylander's comments, that would be very helpful for staff. And so if that can't happen, we've seen some representatives from the labs here. Obviously, Mr. Adler is the petitioner. If those conversations can happen, that would put us in a much better position to have, this workshop in February, March with some of the issues a little bit more fleshed out where we can. So that's all I'd like to add, Chair.
Okay. With that, then we move to our next meeting is scheduled for December 13th of 2022. We've kind of hit items for future agenda. I don't know if we have any others, but that's always open through myself or Mr. Klimas. Our second round of public comments, if anyone wishes to make specific or general public comments, this is the time. Yes, sir.
Good afternoon. Sorry, is it morning? Good morning, Chair Timothy Aliato, speaking. Just representing Cora Lounge as a consumption, social equity consumption lounge applicant. I just wanted to make a statement in regards to the petition, and I just wanted to state that in regards to throughout the whole process with I believe the ILAC team to where we are currently today, there has been some good regulations and some bad that has been in place. And I just wanted to state that we continue to adopt good regulations such as we had in the past with the BCC regulations. And then we could also look forward to add in more, regulations that could protect the consumer overall. And I'm glad the petition was denied because it would have been a huge liability for consumers. Thanks for your time.
Thank you. Any other public comment for the record this morning? Seeing no one else, and did you wish to make a public comment, sir? Or any public comment in Carson City?
Will Adler, representing the Silver State Government Relations, representing the Sierra Cannabis Coalition. I just want to thank you all for your time today and your hearing of the petition. I would take this opportunity to work with the Nevada Cannabis Association, as Director Klimas said, and invite any laboratory participation as well, because I ultimately the goal of the petition was to get a workshop around laboratory testing in Nevada opened. I would just state that I don't feel that the petition and its premise should be the limits of those conversations, that there may be topics that the laboratories wish to bring up themselves, and that we'll incorporate those in the fact finding prior to the workshop. And hopefully we can document this in some way through the CCB and participation of their staff as well. Thank you very much.
Any other public comment, Carson City? Hearing none, that moves us to item 13, which is adjournment, or recess, as we used to say in grammar school. We are in recess.